let my children eat. Even a little is enough. Whatever happens to me, I can bear it. Just please let my children eat.
Hello, my friends. Come in, settle down, and let the noise of the outside world move a little farther away. I want you to imagine a quiet room. Picture a heavy wooden bench, the soft, repetitive shuffle of legal papers, the familiar echo of worn shoes on courthouse tile, and a kind of silence that does not feel empty, but full of worry, full of hope, full of unspoken stories waiting desperately to be told. That is exactly where we need to begin today. Not with a complex legal argument, not with a rigid rulebook, and certainly not with a cold speech about punishment or procedure. We begin with a simple, undeniable truth. Every courtroom, at its absolute best, is a place where human beings arrive, carrying heavy burdens that simply do not fit neatly inside a manila file folder. In the courtroom of Judge Boyd, a case number might identify a matter on the morning docket, but it cannot tell you how someone slept the night before. It cannot tell you whether there was food in their kitchen, whether a sick child was coughing in the next room, or whether a parent's pride was the only thing keeping them from shattering into pieces right there on the stand. A piece of paper cannot tell you whether the person standing before the bench is one bad break away from completely falling apart or one act of mercy away from finding a better path. People often ask why the justice system can feel so incredibly cold. They ask why some courtrooms seem to run like factories, processing human lives on an assembly line. They ask why the law can appear so mechanical, so entirely stripped of tenderness, and so hopelessly distant from the bleeding realities of ordinary life. I understand that question completely, because there is a terrifying truth inside it. If all a judge sees is a broken statute, a mandatory fee schedule, a prior record, or a box to check before the lunch recess, then justice simply becomes a machine. It categorizes, it stamps, it penalizes, and it moves on. It can be highly efficient, it can be perfectly orderly, but let me tell you a secret. Consistency without wisdom can easily become cruelty wearing a neat suit. Sameness is not always fairness. There is a profound difference between treating people equally before the law and pretending that every single situation carries the exact same moral weight. A reckless individual acting out of pure arrogance and a starving mother driven by absolute desperation may stand on the exact same floor tiles under the exact same ceiling, but they do not stand there for the same reasons. And they certainly do not need the exact same answer from the bench. Over the years on the bench, one lesson has settled deeper in my mind than almost any other. What really matters in my courtroom is not merely what a person did, though actions certainly matter. Harm matters. Responsibility matters. But the deeper questions must always be asked. Who is this person standing in front of me? Why are they really here? What invisible load are they carrying on their shoulders? Would punishment restore order? Or would it simply deepen an already unbearable suffering? Would mercy heal a broken life, or would it just enable bad habits? The case that answered these questions for me walked into my courtroom on a cold, rainy Tuesday morning. It was the kind of morning that makes the whole city seem exhausted before the day has even truly begun. The sky hung low and gray outside the tall courthouse windows. The clerk was shuffling her endless stacks of paper. The bailiff stood quietly by the wooden rail, and a long list of routine traffic cases waited to be called. They were the sort of matters that usually blur together by late afternoon. Then, one specific file came forward, and before the hearing was even halfway finished, I knew this case would stay with me forever. Her name was Maria. She was a mother in her early 30s, slight, worn down, and carrying herself with the rigid, trembling effort of someone absolutely determined not to unravel in a public place. Her hair was pulled back quickly, as if her morning had demanded pure survival from the very minute she woke up. Her jacket was faded from far too many washings. Her shoes had a specific lona that I have learned to recognize after all these years, not stylishly worn, but worked thin by the relentless demands of a desperately hard life. She stood before me, clutching a crumpled folder tightly to her chest, as if it were her only shield against the overwhelming authority of the room. The charge itself was painfully ordinary: a suspended vehicle registration, a lapsed insurance policy, and a growing pile of administrative late fees. It was all cleanly printed on a pristine white document as if clerical neatness could somehow reduce human misery into a perfectly manageable checklist. I looked down at the file, and then I looked up at her face. There was a massive, heartbreaking distance between the cold ink on that paper and the profound exhaustion in her eyes. When I asked her to explain the violation, she did something that always commands my immediate respect. She did not begin with a web of evasion. She did not argue, and she did not blame the police officer. She simply looked at me, took a very shaky breath, admitted she was entirely in the wrong, and quietly stated that she just did not have the money to fix it. That simple statement, "I just didn't have the money," did not tell the entire story, but it gently pushed open the door to a heartbreaking reality. As the hearing continued, the details of her life began to surface slowly. It wasn't because she was putting on a theatrical performance for the court. It was because profound hardship often reveals itself in painful, humiliating layers. She lived in a cramped, third-floor apartment with her two young daughters, aged 9 and 6. She worked exhaustingly long hours, cleaning motel rooms part-time, and picked up evening shifts at a local diner whenever she could beg the manager for extra hours. But her income, even during a good week, barely held together a remarkably fragile household budget. There was rent to cover, there were utility bills to keep the heat from being shut off, there were groceries to stretch, and then there were those ordinary, sudden emergencies that completely transform poverty from a difficult condition into a terrifying series of relentless disasters. Her youngest daughter had developed severe bronchitis. Medicine had to be paid for in cash. The rent was late. The old car needed a repair just to get her to work. The insurance lapsed. One overdue bill became another, and then another, until the cold administrative machinery of life began punishing the very person least equipped to absorb yet another devastating blow. When Maria finally opened that crumpled folder she was clutching, it became entirely clear that she had not come to my courtroom unprepared. Inside were faded pay stubs, pharmacy receipts for the asthma inhaler, a terrifying final shut-off notice for her electricity, and the kind of folded, wrinkled pieces of paper that, together, tell a story much more honestly than any polished legal testimony ever could. She was a mother desperately trying to prove to a powerful system that her chaos was incredibly real. She explained that she thought she could catch up the following week. And then, in a single sentence that instantly changed the entire emotional temperature of the room, she admitted the unimaginable. With visible embarrassment, staring down at her worn shoes rather than reaching for pity, she confessed that they hadn't eaten right the day before. She quietly clarified that she had managed to feed the children a small meal, but she had completely starved herself. The courtroom fell into that rare, heavy silence that arrives only when everyone present suddenly understands that this is no longer just a paperwork case. The air in the room seemed to thicken, pressing down on the shoulders of the lawyers, the clerk, and the curious onlookers in the back rows. A simple suspended registration had suddenly become a wide, painful window into the thin, jagged edge between survival and total collapse. At that moment, I looked at Maria, and I didn't see a defendant. I saw a woman standing on the precipice of a disaster that no legal statute could properly measure. When I asked her if the insurance was current now, her hands trembled as she reached into that worn, wrinkled folder and handed up the proof. She had managed to fix the problem as best as she possibly could before standing in front of me. She had prioritized her legal responsibilities even when she could not prioritize her own hunger. Her record was clean. There was no prior pattern of abuse, no repeated disregard for the rules of the road, and no long history of ignoring the authority of the state. There was absolutely no swagger in her posture, no manipulative confidence in her voice, and certainly no contempt for the court. She was simply a person who had been overwhelmed by the sheer, crushing weight of being poor and alone. This is where the law becomes truly difficult for a judge. The bench often gives me a wide range of options. It allows for penalties, it allows for collection, and it allows for the smooth, cold functioning of the administrative system. On paper, I could have easily imposed a fine that would have satisfied the state's ledger. I could have checked the box, cleared the docket, and moved on to the next case before the lunch recess. But the mere existence of a permissible consequence does not answer the much deeper moral question of whether applying it in that specific moment actually serves the ends of justice. If I took another 50 or $100 from this woman, I wouldn't be upholding the law. I would be taking grocery money away from a household already strained by hunger. I would be punishing children who had done nothing wrong. I would be turning a corrected administrative violation into a deeper family hardship and calling the result fairness. But I have learned that consistency without wisdom is not justice, it is just indifference spoken in the language of procedure. Justice must be wide enough to hold both mercy and firmness without losing itself. In that moment, I knew Maria didn't need a penalty. She needed the room to breathe. So I did what the law allows, but what a heart for justice demands. I looked at Maria and told her that the fine was waived. I told her the court costs were gone. I wiped the legal slate clean. But the most important part of that moment was not the legal waiver itself. It was the recognition behind it. She covered her mouth with a trembling hand and began to cry. It wasn't the cry of someone who had won a game or escaped a trap. It was the sound of a human body finally letting go, the sound of someone whose nervous system no longer had to hold the full, terrifying force of panic for at least one more day. The hearing moved on. Because court calendars are relentless, and they do not stop for every emotional truth that enters the room. Yet, my thoughts stayed firmly with her. When there was a brief break in the proceedings, I asked her to stay so we could speak more directly. As often happens with dignified people in desperate situations, her first instinct was to say she would figure it out. But life had already demonstrated that figuring it out alone had become nearly impossible. The fuller truth came out in fragments, whispered in the quiet corner of the courtroom. The refrigerator was almost entirely empty. Her older daughter had started pretending she wasn't hungry, just so the younger one could have a little more to eat. The landlord had already issued the first warnings. There was no family close enough to rely on, no savings, and no cushion between a bad week and a total catastrophe. What struck me most was not only the level of her hardship, but the persistence of her effort within it. She had not stopped trying. She had kept working, kept gathering her documents, and appeared in court with as much dignity as she could still manage. In my years on the bench, I have come to believe that mercy is not softness. Mercy is precision. It is knowing exactly now punishment serves no moral purpose except to make a wounded life bleed more. It is not blindness to wrongdoing. It is actually a much clearer sight. It is the recognition that a just response must consider not only the rule that was broken, but the human reality surrounding the break. So, we took practical steps, a call to a food pantry contact, guidance toward emergency utility assistance. Nothing grand, just the ordinary acts of civic mercy that prevent a temporary The law alone cannot do everything, but a judge who remembers that every decision radiates outward can at least avoid making a hard life even harder. Weeks passed, and the immediate, suffocating crisis for Maria and her daughters began to slowly stabilize. The emergency food support we arranged bridged that first, impossible gap, and the utility assistance ensured they weren't sitting in a cold, dark apartment wondering if the lights would ever come back on. But the most important thing that happened during that time wasn't the money or the groceries. It was the shift in Maria's spirit. When a person has been drowning in a sea of no for years, one meaningful yes from someone in authority can be the life raft that finally allows them to start swimming toward the shore. Months later, Maria returned to my courtroom. She wasn't there because of a new summons, a missed payment, or a broken rule. She walked in during a quiet moment of the morning session, and for a second, I almost didn't recognize her. She was still the same, slight, dignified woman, but she was standing taller. The hollow, haunted look in her eyes, that specific look of a mother who has forgotten what it feels like to be safe, had been replaced by a quiet, steady light. She had come back simply to update the court. She had taken classes, studied at night after her daughters were asleep, and was now employed full-time at a medical clinic. She told me that her daughters were thriving. The oldest was no longer distracted by the gnawing pain of hunger while trying to learn her multiplication tables. The youngest was breathing clearly, her bronchitis finally a memory of a harder season. Maria had even started volunteering with a local food drive, because she remembered with painful clarity what it felt like to look at an empty kitchen cabinet and feel the world closing in. Her struggle hadn't vanished. Life is rarely that easy, but the trajectory of her life had fundamentally changed. She was no longer just surviving the week, she was beginning to imagine the next year. That case reinforced a belief I have held for decades. Mercy is not a lack of standards. It is the refusal to use power carelessly, when punishment would serve no purpose beyond making a wounded life bleed more. Every ruling teaches a civic lesson. It tells the community whether the system sees them as human beings or just as entries on a ledger. In Maria's courtroom that day, we didn't just waive a fine. We chose to believe that a mother's desperation deserved a road back, not a dead end. But a courtroom cannot run on mercy alone, because there are other stories that walk through those heavy doors. If Maria's case taught me the power of relief, the next case taught me the absolute necessity of resistance. Shortly after Maria left, a young man named Andrew Whitmore stood before me. He was in his early 20s, clean-cut, well-dressed, and carrying himself with the easy, polished assurance of someone long accustomed to being buffered from the consequences of his own actions. Some people enter my court with humility, some with fear, and some with the mild irritation of a customer at a restaurant whose order took too long. Andrew belonged to the last category. His charge was not a one-time oversight born of desperation. It was repeated reckless driving, a prior warning ignored, and conditions previously imposed by another court treated as though they were merely suggestions. He had been speeding far above the limit in an area where pedestrians were present. This was not an accident of inexperience. It was a clear pattern of disregard for the safety of others. Beside him stood a lawyer polished enough to make an entire profession seem made of silk and strategy. The message entered the room before a single word was spoken. This was a young man with resources, representation, and a life in which systems had likely bent helpfully toward him for many years. The lawyer began emphasizing Andrew's future promise, his academic track, and his respectable background. I have heard this language many times. Promise is real, but it is not a moral exemption. In fact, when promise is used as a shield against accountability, it becomes something ugly. The implied argument is that because this person might someday become important, the law should protect that future from the inconvenience of present consequences. That is a quiet form of corruption. It is the habit of valuing some futures more than others because they arrive wrapped in money or social standing. Andrew's own account did not help him. He was late, traffic was bad. He didn't think it was a big deal because everybody speeds there. That word, everybody, has excused more moral laziness than almost any other. It shifts responsibility outward, as if the commonness of a behavior somehow reduces its danger. But repetition does not erase accountability. If the court had reduced Andrew's matter to another manageable payment, it would have taught him the worst possible lesson, that public safety is negotiable if your background is polished enough. Leniency toward the struggling can be wisdom, but leniency toward the arrogant is simply permission. That day, the full fine was imposed on Andrew. Costs were imposed, but more importantly, substantial community service was ordered. I did not order decorative service designed merely to check a box. I ordered enough to interfere with his comfort and force him into contact with lives completely unlike his own. At first, he treated the work as a humiliation. He was late, he was sour in attitude, and he acted as if the labor were beneath him. He expected accommodation because of his background, but he received seriousness from this bench instead. There is a massive difference between the two. Then, something shifted. Contact with reality did what legal arguments could not. Through his service, he encountered people whose practical problems resembled his own, but who handled them with more honesty and grit than he had shown. For the first time, he began to listen more than he talked. He admitted he had treated the court as a negotiation rather than a moral reckoning. By the time his hours were complete, firmness had not destroyed his promise. It had rescued it from becoming rot. Accountability is not the opposite of compassion. Sometimes, accountability is compassion, especially when the real danger is unchecked character. Looking back on these two stories, the lesson becomes plain. Maria needed mercy because punishment would have solved nothing and harmed the innocent children around her. Andrew needed firmness because softness would have ratified his contempt and endangered others. Wisdom distinguishes. This is why I have never been persuaded by the shallow slogan that fairness means treating everyone exactly the same. That idea sounds noble until you realize it requires ignoring motive, circumstance, pattern, and need. The law must be equal in dignity, but justice must be intelligent in application. A judge must never forget how far decisions travel. A waived fine can become a week of groceries and a child sleeping without fear. A firm sanction can become the turning point that teaches a person to stop narrating their life as something that merely happens to them. I do not want to be remembered as lenient or tough. Those are crude categories. I want to be remembered as someone who understood that authority without humanity becomes ugly, and humanity without backbone becomes useless. I still believe justice can have a soul, because when authority is exercised with humility, lives can change direction. Often enough to matter, often enough to justify hope.